Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney, Ms. Sheela Murthy, to discuss the latest updates on immigration, followed by GC process and timelines. You can call the numbers displayed on the screen and ask any question related to immigration, and we'll be glad to get you an answer. We'll start taking calls in few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. For case-specific questions, please contact the attorney. Hi, Ms. Muthi. Welcome to the show.
Hi, good afternoon and good evening to all of you. It's great to see everybody and thank you for joining us.
Yeah, you all know Ms. Murthy is the founder and president of the Murthy Law Firm and Harvard Law School graduate. Also, she's the one behind the famous Murthy.com website with a lot of material out there for free. Please, before getting into the show, could you introduce yourself and then we can take it from there?
Sure. Thank you, Ranjit. As Ranjit just explained to all of you, the Murthy.com website was started almost 27 years ago in the dark ages of the internet. And one of the things that we are so privileged and honored is to provide lots and lots of free content, information, updated, valuable information for 27 years through the Murthy.com weekly Murthy bulletin, through the Murthy chat, through the Murthy forum, which has 150,000 to 200,000 live participants and monitored and provided, and with information being monitored by attorneys at the Murthy law firm, as well as the free monthly teleconferences that we provide for those interested to sign up, employers, HR representatives, and individuals when we have sessions. All of it, again, is to provide valuable, cutting-edge free information so that you are aware of the latest changes dealing with U.S. immigration law. We also share fun and interesting facts on information, movies, articles, blogs on immigration. Again, it's our commitment to share and give back to you, each of you, as our valued members of the immigrant community.
Thanks, Ms. Murthy. Before getting into the updates, we have a caller. Let's take the call. Hi, Sai. Welcome to the show. Please go ahead and ask your question.
I think it got disconnected with Sai.
Okay. Meanwhile, okay, could you please let us know what are the updates from the last weeks? Then we can start from there.
Sure. So as we were just discussing, Ranjit, the U.S. Department of Labor has just released information that the H-1B and the PERM wage rule that was supposed to go into effect, that was postponed by a couple of months, has now been postponed by 18 months until November 14th of 2022. So that gives a little bit of peace of mind and breathing opportunity for many people who were very nervous about the impact on H-1B workers and whether that would eliminate all. Already yesterday, I believe that the U.S. Department of Homeland Security and ICE and CBP released information that there has been a 72% drop in F1 international students applying to U.S. universities. And there's literally cutting edge changes and information on a daily basis that we are seeing with regard to immigration updates, Department of Labor updates, USCIS updates, student and exchange visitor information from SCVP and ICE, because a lot of international students and designated school officials are very confused about the different changing rules with respect to when the student can, enroll in the university, work from abroad, participate, not participate, has to come into the US, is not allowed entry into the US because CBP is not allowing fresh grad students, as you know, unless the university is switching to in-person classes, which a lot of universities are planning now to switch to inline courses and on-campus live sessions in order to encourage international students to come to the United States to pursue their education. But it takes a lot of time, effort, energy, planning, because the COVID-19 vaccinations, while about a quarter of the country has been vaccinated, at least one of the two vaccines, there's still 3/4 that have to be vaccinated, and young people are bottom of the line. But a lot of states, including Maryland, I believe, are opening up next Tuesday to make it available to every adult over the age of 16.
That sounds good. We have the caller again, Sai from Virginia. Hi, Sai. Welcome to the show. Please go ahead and ask your question.
Hi, good afternoon, everyone. Hey, Miss Murthy, this is Sai here from Virginia. Just have a quick question, like general questions. Being on H-1B, USCIS does allow, and is it legal to buy a property or the business? Because what happened when I called the USCIS customer care, they said you need to check back with your immigration attorney.
Yes, of course, the government, the USCIS is not there to help give you advice about your life and your business and how you can make more money, right? Their job is they barely just about understand the complex and ever-changing rules. But from an immigration law point of view, a foreign national on an H-1B like yourself is allowed to purchase property, whether it's your home or a business. However, you are not allowed to work for that business, which of course doesn't make any sense and can be quite confusing. So while you are allowed to invest in any business, you cannot perform work for that business, including hiring a CEO or signing checks or doing any work, because that means you are working without authorization, which is a violation of both the US Department of Labor rules and the US Citizenship and Immigration Service rules. So this is something that you really need to sit down and figure out how you can make something happen, even if it means hiring a person to do 100% of the work or hiring a management company, preferably when you're not physically in the United States, to run the company or run the investment or run the business for you. But no work is permissible because that is a violation of US laws, Department of Labor and Department of Homeland Security laws.
Okay, so the name wouldn't be there, right? So you cannot put your name into the business, though. You can be the sleeping partner or something like that, correct?
You can be a sleeping partner, and if your name is on the business, would they want to give your name? You can name it anything in the world. If you are not having any decision-making capability or doing any work of any nature for that business.
Okay, good to know. Yeah, thank you so much.
Thank you.
Thanks, Sai. Thanks for the call. So, Ms. Murthy, our today's focus of the topic is on the green card. So last week there is a live show from Charles Oppenheim, and they were planning to do it every month from now after the visa bulletin is released. There were quite some updates. If you can share all the updates that are useful, especially to the backlog communities, that would be helpful.
So they did talk about Charlie Oppenheim. By the way, all of you can access the information. It's available on YouTube. As Ranjit just said, it's going to be a monthly program. It just started month of March, this month, March 2021. And it's fantastic. I remember meeting and seeing Charlie speak maybe over 20 years ago. Like all of us, he had a lot more black hair 20 or 25 years ago. We've all grown older and wiser. But he's truly the most knowledgeable person with respect to immigrant visa control unit, processing immigrant visa numbers, backlogs, family-based, employment-based, worldwide quotas, and working very closely with the USCIS to coordinate the issuance of immigrant visa numbers. So they talked about the the family-based, and they went in great detail because, of course, the presidential proclamations had shut that down until a couple of weeks ago. So those weren't even being processed at any of the US consulates. And so all the unused family-based immigrant visa numbers are now being used, going to fall into the employment-based category for use. And one of the interesting things that I thought he mentioned was that we will have an addition. Remember, every year in the employment-based category, for those who are not aware, we get 140,000 total immigrant visa numbers available for EB1, EB2, EB3, the employment-based categories, but an additional 135,000. So immigrant visa numbers will be available, which means we're almost going to get double the immigrant visa numbers available for the next fiscal year, because he said instead of 140,000, it is going to increase to 275,000 immigrant visa numbers. So all of you who are thinking, great, will that mean my priority dates will move forward? Yes, most likely it will. He did talk about it moving forward. He even explained why EB3 is moving faster than EB2, but he said things could change. And so I think it's extremely valuable and important because many people I know when I do consultations over the past 25, 27 years, they always say to me, well, Ms. Murthy, can you explain the visa bulletin, how it works? And I remember the first time Charlie explained it, maybe 20 or 25 years ago, all of us in a room, which was a very large room, were listening to him. And finally, at the end of like 10 minutes or 15 minutes, we all said, we are very grateful that you are doing the job that you're doing, Charlie, and we are doing the job that we are doing, because it really, the way the structuring and the movement of numbers was so burdensome and onerous, and just somebody monitoring it. And back in those days, 27 years ago, we didn't have the technology that you all have today. So I don't know, salute to him and his team in the Immigrant Visa Control Unit division for being able to monitor it at such a, and to a fine, like almost literally like a fine-tuned, well-oiled machine. But there's a lot going on. So bottom line is, for all of you in the family-based and employment-based categories, we expect a much greater availability of numbers. They did say that they will keep releasing it and then monitor usage and then either pull back or again push it forward. But we've seen, and all of us have seen, where like last October, we had a huge influx. We were told that it will continue for the next several months. And guess what? After October, it did not continue at the same pace because they moved it from date of filing to final action date back in the employment category for November and December and January and February and March and April. So they haven't changed it. So we were expecting one thing and something different happened, because when they see how many thousands and thousands, tens of thousands of people ended up filing, I think they decided to roll it back and monitor it more carefully, because they like to ensure that both U.S. Department of State, consular officers, and USCIS officers are not overwhelmed. So they try to monitor the usage, make sure immigrant visa numbers are not wasted, while also trying to see how they can monitor the workflow of the different agencies.
Ms. Murthy, yeah, we were talking about the GC process and the timelines. Could you, a lot of things have been changed in the past few years, and now you very well know that GC process and timelines are like, there's a lot of wait time. If you can just give us a brief at what are the approximate wait times, and what steps should people take, especially the ones who are on the verge of completing their 6-year max out. So could you give just a brief about how long the process is taking these days and what people should be vigilant about?
Sure. So again, when you're referring to the green card, you're referring, Ranjit, to the employment-based green card quotas and processes,
yes.
Not family-based. So obviously, in most employment-based immigration, you have 3 major steps towards the green card process. The first step, of course, is the PERM or labor certification, where you get the U.S. Department of Labor certifies that there is no ready, willing, and available U.S. worker to do that particular job that the employer needs. Previously, a prevailing wage determination used to take, a few weeks. Now it takes several months, a couple months, 2-3 months, just to get the prevailing wage determination from the Department of Labor. Then you have to do all the ads and all of that, where you get the process started. So by the time you file the PERM, that process itself can take 7 to 9 months just to file the PERM. And then once you file it, the Department of Labor can take anywhere from a few months up to a couple of years if there is a Department of Labor audit issued on the case. And once you get the PERM approval, then you file the I-140 petition with the USCIS. So Department of Labor is done, and now you go to USCIS. And the USCIS basically, in the I-140 petition stage, reviews whether the employer has the financial ability to pay the salary, the prevailing wage, as determined by the U.S. Department of Labor for that particular employee to perform that particular job. And the employee has to prove that the employee has the required education and experience and other qualifications in order to get the immigrant visa petition approval. And that when the I-140 petition is approved, then the priority date is assigned, but it goes back to the date of filing the PERM, that is the priority date, but it's not given and locked in until the I-140 petition is approved. For those whose H-1s are expiring, If you have an I-140 approval, as you know, you can get a 3-year H-1 extension. If you don't have an I-140 approval, then the perm must be filed minimum 365 days earlier to get the 1-year H-1B extension, because based on a filed perm minimum 365 days earlier. That is why you need to discuss, if you're the employer, file the case minimum when the person has minimum 2 years remaining on the 6 years of H-1B status. Otherwise, the candidate or the employee may be forced to travel abroad and stay either in India or some other country and have to depart the United States. We are seeing a lot of people, by the way, applying now to immigrate, to get a work permit or to immigrate to Canada, because it is actually happening very quickly. Combination of the economy heating up and things changing, and the overall demand for workers that Canada loves. Canada has been inviting and very excited to get high-skilled, technical, talented workforce to join their workforce. So Canadian work permit is just taking a few months, and the green card is based on factors like your education, your age, your ability to speak French. They have a points-based system. So take advantage of that. People go there for sometimes a year or two and then come back to the US for H-1B. There's so many million ways in which you can try to understand and figure out how to make this work for you and your family. The big advantage of Canada that a lot of Indian people prefer is, of course, you can bring your parents as a permanent resident, unlike the United States where you have to wait till you become a US citizen to sponsor your mother or father or parents for the US green card. In Canada, you can bring them in as permanent residents to join you. Now, if they have a complex medical situation or medical problems, then they are less receptive, because unlike the United States, in Canada, the federal government, the Canadian central government basically pays for all medical care. So they're not excited about having to incur millions of dollars or hundreds of thousands of dollars in medical field bills. But a lot of people use that to bring their parents, bring their family, get the Canadian citizenship, Canadian work permit, green card, then citizenship, and then try to come in as TN workers into the United States to work, and then go through the green card, especially if you have an old priority date that you locked in by filing a labor and perm. So as you can see, there's so many creative ways that we can, figure out based on your individual situation, based on your background, based on your family situation, and the importance for some people of not leaving their widowed mother alone in India or something, that becomes, because many people go back to India to stay with their parents in their as they grow elderly in their old age. Well, maybe Canada will solve that problem for you, if that makes sense.
Sounds good, Ms. Murthy. So is there any way to expedite the labor, the perm, or the PWD, because it's taking a lot of time? Is there any way, like USCIS has a premium process, and do we have any channel to talk to Department of Labor where people are in need whose things are to be expedited?
So in general, the Department of Labor, their process is their process. There is no premium processing program because you're not paying any separate fee. Over the years, they have actually talked about imposing a 10% of the person's salary as a processing fee. So if your salary is $60,000, $6,000 Department of Labor fee, if your salary is $120,000, $12,000 Department of Labor processing fee, they haven't implemented that yet because the attitude is it's not a pay for service. It is meant to protect US workers and not make it easy for foreign workers then to say, I'm your client or customer, take good care of me and give me my service immediately, like the way USCIS has the premium processing program. So the Department of Labor's attitude is, look, you knew on the first day you walked into the US on H-1, you had 6 years. If you didn't file it in year 1, 2, or 3, why is that our problem? Why should we do something expedited because you messed up your life or were not organized? And they say that our job is not to protect or help the foreign worker. Our job is actually to help and protect the American worker, to ensure that the foreign national worker is not taking away a job from a US worker that is ready, willing, and able to perform that job. And their main job is to protect the wages and working conditions for US workers. Remember, the Department of Labor's attitude is not like the USCIS, where S stands for service, and they are supposed to provide service to us as employers and employees processing the immigration paperwork.
Sounds good, Ms. Murthy. Other question we have a lot of people are asking is about a lot of people who have I-140s, the companies get acquired, they merge. There is a lot of other things that happen. So what are the situations that, need to keep in mind when the company is either acquired or merged or whatever happens? Is there a need to file another I-140?
So it depends on the situation. If the perm is still pending when when their employer merges, there's a whole section, body of law and cases, and USCIS has spoken in different events about how this works. But primarily, if the perm is still pending or the labor certification is still pending, then you would be able to file the I-140 petition with the new entity's name showing the merger documents or successor and interest proof of the documents. If the I-140 was previously filed and approved, then in general, yes, you're required to file a new I-140 petition with the new employer showing that they are taking over because they have to be responsible financially and otherwise to take over the case for the employee that is joining this merged entity. Obviously, if the merger or acquisition takes place after the I-485 is filed, then after 180 days, we can say that even if it's a new employer, that as long as we can show same or similar job duties, you will be able to continue that same 485 and green card process without adding anything more other than possibly a supplement J into that folder. But other than that, if it's after the perm is approved, after the I-140 is approved, in general, yes, a I-140 petition is required to be filed. And we've seen some pushback where USCIS gets confused and says, but you were not there when that perm was approved. So you would basically file it as an I-140 based on the new entity agreeing and acting as a successor in interest, agreeing to take all the liabilities and obligations of the prior entity with respect to the green card processing.
Got it, Ms. Murthy. We have a caller, Kishore from Pennsylvania. Let's take the call. Hi, Kishore. Welcome to the show. Please go ahead and ask your question.
Hi. Thank you, ma'am. This is regarding H-1B registration cap related. So my question is generally USCIS declares that we have received sufficient number of applications. So since only 2 more days have been left, so has that news been declared?
No. Kishore, just so you understand, this is the pre-registration system. This is not filing.
Okay.
We are not filing like in the olden days, we were actually filing the petitions starting April 1st. Now this last year and this year, what the USCIS did was they accepted pre-registration, means the employer has to just provide certain minimal information saying, I intend to file an H-1B petition for this employee with this name, this date of birth, this passport number, whatever the minimal information. And the dates are, as you know, from March 9th to March 25th. After they file it before March 31st, the USCIS will give the results of who all have been selected to file the H-1B cap subject petition. And the employer and employee can prepare and file the documents starting from April 1st of 2021 for 3 full months, for April, May, and June until June 30th of 2021. If you remember last year, about a month or 2 after they said they had picked all the candidates, they said they realized that not enough people had filed H-1 petitions in the months of April, May, and June. So in July, for the first 2 weeks in July, they actually issued and released more lottery winners so that maybe about 10% more cases because of the COVID-19. A lot of employers did not take advantage and file all the petitions that they had planned to file because the economy and their business was impacted, and many of them may have lost some client projects or other work.
Okay, got it. Thanks.
Thank you, Kishore.
Okay, hope that answered your question. Thanks for calling, Kishore. Yeah, Ms. Murthy, other question a lot of people have regarding offline is, we know when I-765 and I-131 advance parole and EAD are filed with 485, there is no fees. There is a lot of news going around. If they have to apply it separately, do they have to pay the fees?
So it depends also when the petition was filed, right? So it depends on when the adjustment of status application, because the fees have been changed. At one point, everything was all included in one fee, and then they changed the fees last year. The fees, so procedural and issues dealing with process, we have a whole team of paralegals and legal assistants and attorneys that do that work. So in general, it's not sort of a high-end legal issue, but depending on when the adjustment of status application, the AOS 485 package was filed, you may have to pay a separate for it EAD and AP fee, or it could be included in the application. But in general, most people have to pay a completely separate of 765 and I-131 fee for the advanced parole, the EAD and advanced parole, because the government first said increase the fees dramatically to include all the fees in one umbrella case, and then quietly kept most of the fees and then charged it again. So it's a crazy business. If you and I had to do that kind of business, we would be chased away for committing fraud and misrepresentation and doing all kinds of illegal things, taking advantage of people. But it's the federal government. They have a monopoly on issuing green cards, and they have managed to tell us that everything will be included if you pay this one fee, and then they quietly separated it and kept most of the fee and then added more for I-765 and I-131s. So be careful. Make sure two things. Many of the forms, by the way, the latest forms have not yet been released. They've just released a new version of October 2020 for mandatory forms that have to be used for H-1B petitions and several other petitions, as you know. And if you use an older version, your case could get denied or kicked back. And that's one of the many, many changes from a procedure point of view. If you're not a lawyer or reading information on a daily basis or working with somebody that is focusing their time, you could very easily get mixed up and confused. So many people come to our firm after their case is rejected because they made a mistake with the check or the filing fee or the date or the amount, or using an older version of the form. You have to look at the date and the validity of the form, and they will say this form can only be used until this date. And if you don't know it or aren't keeping up with it, you file your case, especially if it's a cap subject petition, you get it rejected, then the cap is you, because they take 2 or 3 months to return it back to you. The gate is shut down. Now you cannot file your case because you lost the window of opportunity. So be very, very careful. Either hire a professional or monitor it so carefully that you cannot afford to make a human error.
Thanks, Ms. Murthy. We are toward the end of the show. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every Tuesday at 3 p.m. EST to watch the special immigration show. Again, it's every Tuesday, 3 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Ms. Murthy.
Thank you very much.